You moved to Florida. You updated your driver's license. You registered to vote. You filed for homestead exemption and you think you're all set. But here's the truth. Your estate plan from up north may have just become a financial disaster waiting to happen. In fact, I just met with a couple last month who discovered their Minnesota estate plan was about to cost their kids an extra $48,000 in probate fees. And that was just the beginning of their problems. Hi, I'm Chuck Roulet, and I've been practicing estate and elder law for almost 30 years in both Minnesota and Florida. And today I'm going to show you the 5 biggest mistakes snowbirds make with their estate plans when they move to Florida, and more importantly, how to fix them before it's too late. Now, before we begin, if you haven't already, make sure you click the like and subscribe button so you'll be notified when I post new videos like this one. And make sure to share it with anyone that may find the information helpful. If you have a question, post it in the comments and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. All right, here's mistake number 1, keeping your will-based plan instead of switching to a trust. Here's what most people don't realize. Probate in Florida can be very expensive. Under Florida Statute Section 733.617, probate fees are calculated as a percentage of your estate, and it starts at 3% of the value of your estate. So for example, if your home and everything results in an $800,000 estate, you're looking at potentially $24,000 to the personal representative and another $24,000 to the estate attorney. That's $48,000 total coming right out of what you plan to leave your kids. And if you move from a state like Pennsylvania, where probate is relatively quick and inexpensive, this is going to shock you. But here's where it gets even worse. Remember that lake cabin you still own up north? Your home that you've kept for when you go back to visit the kids and grandkids. If those are still in your name when you die, your family faces probate in both states. Different attorneys, different courts, more fees, more delays. A properly structured revocable living trust, on the other hand, can avoid probate in Florida and in every other state where you own property. So if you move to Florida with a will-based plan, switching to a trust isn't just smart planning, it's essential. Now, mistake number 2 is not updating your trust to protect your Florida homestead benefits. Now listen, Florida homestead is one of the most powerful asset protection tools in the country. You get up to $50,000 in property tax exemptions. You get a 3% cap on how much your assessed value can increase each year, which can save you thousands as property values increase. And you also get significant creditor protection. But here's the trap. When you transfer your Florida home into a trust, Florida law requires specific language to maintain all of these benefits. So if your trust was created in Minnesota, New York, Virginia, Pennsylvania, or anywhere else, it almost certainly doesn't include this Florida-specific language. And without it, you may lose your tax exemption, your assessment cap, and your creditor protection. That could cost you $1,500 to $2,000 or more every single year. I've reviewed numerous out-of-state trusts, and I can count on one hand how many had the right language. And the fix is simple. Amend your trust to include Florida's required provisions. But most people don't know they need to do this until it's too late. Now, mistake number 3 is thinking you've escaped state estate taxes just because you moved to Florida. So while Florida has no state estate tax, that's one reason you moved here, right? But here's what catches people. If you still own property in a state that has its own estate tax, that state may still tax you when you die, even though you're a Florida resident. For example, just last year, a couple came to me after establishing Florida residency. They'd worked with a different Florida attorney to update their estate plan. Everything seemed fine. But I discovered they still owned property in Minnesota worth about $5 million. Minnesota has a state estate tax with only a $3 million exemption. Neither they nor their previous Florida attorney, who was great by the way, realized Minnesota could still tax those assets. Their kids were facing a potential $800,000 tax bill that nobody saw coming. So states like Minnesota, New York, Massachusetts, Oregon, Illinois, they all have their own estate taxes. And if you still own property there, your estate could be hit with massive taxes even though you live in Florida. Mistake number 4, assuming your estate plan from up north protects your home and savings from long-term care and nursing home costs. Here's the reality. In Florida, your homestead is protected from Medicaid estate recovery, but only if it doesn't go through probate and it's below the equity limits. But that home you still own in Minnesota, that condo in Pennsylvania, zero protection. Those properties count against you for Medicaid eligibility, and they're fully subject to estate recovery when you die. And here's something a lot of people don't consider when they move to Florida. What if you move back up north at 80 to be closer to your kids when you need care? Your plan needs to work in both states. I worked with a couple last year that owned a small condo in Minnesota and a home in Florida, and the wife had recently been diagnosed with Alzheimer's. I was able to set up a plan to protect their home and savings, ensure she got the care she needed, and that would work in both Minnesota and Florida. Mistake number 5 is keeping your old power of attorney instead of getting a Florida compliant one. I see this often. Someone becomes incapacitated. Their spouse tries to access bank accounts with a power of attorney from Wisconsin, Illinois, New York, or Minnesota, and the bank refuses it. Why? Well, it's because Florida statutes, Chapter 709, has specific requirements for powers of attorney. Banks in Florida don't want to accept documents that might not comply with Florida law. So they often either reject it or demand weeks of legal review, exactly when your family may desperately need access to funds to pay for something. I've seen families forced into guardianship proceedings simply because the bank wouldn't accept an out-of-state power of attorney. So updating your power of attorney to comply with Florida law could save your family tens of thousands and months of stress. So what should you do if you've moved to Florida and haven't updated your estate plan? First, don't panic. Often we can update and modify your existing plan, but the update does need to happen, and the sooner the better. You need to review your trust and make sure it includes Florida homestead language. You should consider switching from a will to a trust if you haven't already. You need to review any property you still own up north for estate tax and Medicaid issues, and you need Florida-compliant powers of attorney and healthcare documents. Some of the most expensive estate planning mistakes I see are the ones that could have been prevented with a simple update. If you would like to discover more or to schedule a consultation to discuss your own planning, visit us at roulettelaw.com. And if you would like to discover more, join us in my upcoming exclusive masterclass, where I'll reveal strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. You can click the link in the description below to sign up and join us. And if you would like to discover more about how you can establish Florida residency, get your copy of my book, The Florida Snowbird Guide, a fast and friendly legal guide for Florida relocation and snowbirds, and you can get a copy by clicking the link in the description below. Don't let an outdated estate plan put everything you've worked for at risk. I look forward to seeing you in an upcoming video and the masterclass. Be well.